All right, good evening, everyone. My name is Mary McNicholas, and this is Ariel Rosen, and we're the co-vice presidents of Law Women. It's my pleasure to welcome you to the 2023 Law Women Alumni Reception, our first in-person reception since 2020. We are so grateful for this space and time to celebrate alumni who have been groundbreakers in the field of law and to connect and reunite with one another as current and former NYU law students. I'm especially excited to welcome our admitted students here tonight because this reception was actually the first event I attended at NYU Law. We all hope that by this time next year, we can count you among our members as well. This year has had both its challenges and triumphs. When Ariel and I took on our roles, we pledged to continue strengthening our group's commitment to diversity, proactive advocacy, and community building. Supporting reproductive justice has been one of Law Women's top priorities this year. Our advocacy committee organized a sweatshirt giveaway to facilitate individual donations to abortion funds in states that lack access. Our partnerships committee put on a community event through our Pregnant and Parenting initiative for parents, for students and their families to connect at NYU Law. And we strengthened our ties with student organizations throughout the NYU Law community, like co-sponsoring an American Constitution Society trip to Pennsylvania for poll observing, co-hosting a letter writing drive for Transgender Awareness Week without Law, and putting on panels and events with our friends from other affinity groups across the school.
Now more than ever, we are striving to create programming that empowers women from all backgrounds with the resources and community they need to become leaders in the legal field. This year, we are settling into our new normal as we have begun hosting all of our usual events in person again. This includes panels discussing academic success and career paths, as well as events devoted to community building, mentorship, mental health, and advocacy. We have continued our annual peer mentoring program, matching over 110 first-year students with upper-class women mentors, and have recommenced our high school mentorship program after a pause during the pandemic. Additionally, our board continues to coordinate an attorney mentoring program, which matches students with attorneys in their practice areas of interest for career guidance. Finally, our board is in the process of finalizing the setup of the Law Women Endowment Fund, which will be distributed to help meet the needs of our community members. As part of our community building efforts, we greatly value the opportunity to create a strong network of past and present students who can learn from each other. This event is an important part of that. Tonight, we look forward to hearing and learning from this year's alumna honoree, Stephanie Toti. Her remarks will surely bring up many compelling ideas, so please save your questions for a Q&A immediately afterward, and we will try to get to as many of them as possible. Now, please join me in welcoming Dean Troy McKenzie.
Well, thank you. It's wonderful to see all of you here this evening, and it really is my pleasure to welcome you on behalf of the law school to this year's Law Women Alumni Reception. This is a hallmark event for the law school for a number of reasons. First of all, as was just mentioned, it's great to be back in person, and it's great to have that sense of colleagueship and connection that comes from welcoming a group of people together to hear and to honor an amazing member of our profession and alum. But it's also a recognition of the extraordinary history that NYU has as a place that encourages leadership in the profession for everyone. And NYU has a history that dates back to the 19th century of admitting women to our JD program. The first female graduates of NYU were admitted in 1890, which was decades before other law schools did the same thing. Not that anyone's keeping track, but it was 18 years before Yale, 37 years before Columbia, and 60 years before Harvard, but again, no one is keeping track. And when you look out on some of our most extraordinary graduates, you see names of women throughout the years. Rosalie Lowy Whitney, class of 1895, who was the first female lawyer to try a case in state Supreme Court in New York, and the first woman attorney-in-chief of the Legal Aid Society, class of 1895. The great Chief Judge Judith Kaye, class of 1962, the first female Chief Judge of the state of New York, the first female member of the New York Court of Appeals. We recently, yes, and a legendary figure in the law in this state. In fact, we recently unveiled a wonderful portrait of her in Greenberg Lounge so that she joined many other luminaries who are commemorated there. We can also think of more recent graduates. Our graduate Sherilyn Ifill, class of 1987, who served as president and director counsel of the NAACP Legal Defense Fund, who recently stepped down from that position and is now a senior fellow at the Ford Foundation and is an extraordinary example of leadership in the profession. Or Ria Tobacco Marr, class of 2008, director of the ACLU Women's Rights Project, who also oversees that organization's litigation with respect to women's rights. So over the years, NYU law has ensured that women have become leaders of the legal profession, of the judiciary, of government, of business, and public service as well. I will not give a full introduction of Stephanie Toti, but I just wanted to say a few words of welcome and congratulations. We honor her, Senior Counsel and Project Director of the Lawyering Project. She is going to be formally introduced in a few moments, but I just want to say how grateful all of us are to welcome you back to the law school, how proud we are of all of your accomplishments and of your amazing career. So with that, I would like to welcome to the podium co-chairs Rachel Burns, Martha Stroutman. They will present the Law Women Alumna of the Year Award.
Thank you, Dean McKenzie, and thank you to everyone for coming out to tonight's event. My name is Martha Stroutman, and this is Rachel Burns, and we are the co-presidents of Law Women. As Mary and Ariel mentioned, we are so excited to celebrate with you all in person and hear from our honoree about her inspiring journey through the legal fields. It is our honor to present our 2023 Alumna of the Year Award to Stephanie Toti. As I'm sure everybody in the room is unfortunately aware, it is an understatement to say that reproductive rights advocacy has become even more critical in this past year. The Dobbs decision has already put millions of people's lives and health into jeopardy and will continue to cause irreparable harm to women and all people who can become pregnant. 13 states have now made abortion illegal, and even more are fighting to do so. In the 2 months following the Dobbs decision, approximately 10,000 fewer legal abortions happened in the U.S. By the end of October of last year, at least 66 U.S. abortion providers had closed. We know that criminalizing abortion does not prevent it. It simply makes it unsafe and disproportionately affects low-income people and people of color's access to it. People are now suffering under the greater financial burden of needing to travel to access reproductive health care, and those who are now forced against their will to carry pregnancies to term will, among other things, face grave health risks. At the same time, the decision has also resulted in a surge of advocacy, including legislative campaigns at the state level and grassroots efforts like abortion funds. 10 states have expanded access and protections for reproductive rights since the Dobbs decision. State ballot measures in California, Michigan, Vermont, Kansas, Kentucky, and Montana last year also either codified abortion rights or rejected measures that would have restricted abortion access. In January, just this January, the Justice Department announced that the USPS will be allowed to deliver abortion pills, even in restrictive states. Advocacy organizations like Stephanie's have been crucial in expanding access to medication abortion and pushing back against the barrage of restrictive state legislation. This past year, her organization has worked on a case challenging an Indiana law passed in the wake of Dobbs, which eliminates abortion clinics and imposes felony-level criminal penalties on abortion providers.
It is for these reasons and many more that we have chosen Stephanie as this year's honoree. Over the course of her career, she has litigated numerous cases in federal and state courts throughout the country to improve access to reproductive health care and strengthen legal norms concerning liberty and equality. Stephanie began her legal journey here at NYU School of Law in the class of 2003. Upon graduating, she served as an associate at Freed, Frank, Harris, Shriver, and Jacobson before clerking for the Honorable Nina Gershon, a U.S. District Court judge in the Eastern District of New York. She then spent the next 12 years as a litigator at the Center for Reproductive Rights. In 2016, she successfully argued Whole Woman's Health versus Hellerstedt before the Supreme Court as lead counsel. In that landmark decision, the court struck down a pair of Texas laws that threatened to shutter abortion clinics across the state. Hellerstedt clarified the scope of constitutional protection for abortion rights and was undoubtedly a turning point decision. Then, in 2017, Stephanie founded the Lawyering Project, where she currently serves as senior counsel and project director. The Lawyering Project is an organization aimed at improving access to reproductive health care and upholding the rights and dignity of people seeking and providing abortion care in the U.S. They litigate cases all over the country, and their work advances and highlights an intersectional framework. As Martha mentioned, the organization's constitutional litigation program engages the courts to eliminate unconstitutional obstacles to reproductive health services and to reinforce the constitutional foundations for reproductive rights, such as personal liberty, gender equality, and religious freedom, while also promoting equity and access to care. The Lawyering Project also has an Access and Innovation program, which offers pro bono legal assistance to researchers investigating strategies to provide care and access to medication abortion via telemedicine. They also supply legal assistance to abortion providers relating to legal and regulatory issues that affect their practice. On top of being an experienced and successful litigator for reproductive rights, Stephanie also serves as a member of the board of directors of Whole Woman's Health Alliance and is an adjunct professor at St. John's Law School. It is our great privilege to hear about Stephanie's historic work and impressive career, and we are honored to have her here with us tonight. Please join us in welcoming the 2023 NYU Law Women Alumna of the Year, Stephanie Toti.
And then I think we present this to her, and then can we hold it? Thank you so much. I dropped that.
Well, hello, everyone, and good evening. I'd like to thank Dean McKenzie, the NYU Law Women, and Rachel and Martha for that lovely introduction. At the risk of stating the obvious, pregnancy is a life-altering condition with far-reaching physical, emotional, spiritual, and economic consequences. A pregnant person experiences palpable physical symptoms like nausea, fatigue, weight gain, increased urination, and swelling of the feet, not just for days or weeks, but for months. Pregnancy carries serious health risks, including death. Maternal mortality has reached crisis levels in the United States, especially in Black communities where people die from pregnancy-related causes at 2.5 times the rate of their white counterparts. At least 1 in 8 people who give birth experience serious postpartum depression. Moreover, pregnant individuals who seek abortion care but are unable to obtain it experience greater poverty and unemployment and are more likely to remain in contact with abusive partners than people who are able to obtain a wanted abortion. Access to legal abortion care is therefore not only a public health imperative, it is vital to the dignity, equality, bodily integrity, and religious liberty of women and all people who can become pregnant. My career as a lawyer has largely focused on protecting access to abortion and other reproductive rights. And I'm really sorry, guys, that after 20 years, I don't have more to show for it. But tonight, I'd like to share some reflections on my professional journey, as well as on the Supreme Court's recent decision to overturn Roe v. Wade and our collective path forward towards achieving reproductive justice. When I began practicing law in the early 2000s, the abortion rights landscape was mixed. Roe v. Wade was the law of the land, but so was Harris v. McCrae. Roe, of course, recognized a right to pre-viability abortion care. Harris, however, held that notwithstanding Roe, the government could exclude coverage for abortion from public health insurance programs like Medicaid. The combination of these two decisions meant that although everyone in the US had a right to abortion on paper, millions of Americans had to struggle in practice to afford access to the procedure. During this time, states hostile to abortion rights began experimenting with new types of laws to limit abortion access. These included targeted regulation of abortion providers, or TRAP laws, which imposed medically unnecessary licensing and physical plant requirements on abortion providers and abortion facilities. The goal of these laws was to reduce access to abortion by reducing the number of providers and facilities able to offer abortion care. Like many abortion restrictions, TRAP laws have a disparate impact on low-income people, people of color, immigrants, and adolescents without parental support, all of whom face barriers to long-distance travel. Around this time, abortion opponents also began lobbying for bans on a method of pre-viability abortion used during the second trimester in an effort to stigmatize people who need abortion care at this stage of pregnancy and leverage misogynistic tropes about women's fragility and decision-making. Legal challenges to these bans ultimately led to the Supreme Court's 2007 decision in Gonzalez v. Carhart. The oral argument in that case, held in November of 2006, was the occasion for my first trip to the Supreme Court. Given that I had only been practicing law for a short time, I was not yet eligible for membership in the Supreme Court bar. As a result, I had to wait in line in front of the courthouse overnight in the pouring rain to ensure that I would be admitted to the courtroom for the arguments. It was actually a day a lot like today. It was pretty miserable out. I'll never forget it. The next morning, I got seated in the last row, drenched, shivering, and tired, which might have seemed an inauspicious introduction to the world of Supreme Court practice. But I was thrilled by the arguments and awestruck by the court. I left hoping that someday I would have the opportunity to argue an important case at the Supreme Court. 10 years later, that opportunity materialized. In March of 2016, I once again visited the Supreme Court for oral arguments in an abortion rights case, but this time I was lead counsel for the plaintiffs. Instead of having to camp out overnight, I was able to walk right up to the courthouse entrance on the morning of the argument and claim a seat at counsel table. Like my oral argument experiences, the decisions in Gonzalez and Whole Women's Health were also a striking contrast. Gonzalez had been a setback for abortion rights. The Supreme Court upheld a federal ban on an emerging method of second trimester abortion that used a less invasive technique, which provided significant benefits to patients. The decision signaled a willingness by the Supreme Court to accept junk science about abortion and to act on deeply misguided beliefs about pregnant women's decision-making capacity. In contrast, Whole Women's Health struck down a pair of medically unnecessary TRAP laws that would have shuttered more than 3/4 of the abortion clinics in Texas. There, the Supreme Court held for the first time that abortion restrictions must be supported by record evidence, and that neither legislatures nor courts could rely on junk science as the basis for curtailing a fundamental right. It appeared at the time that the decision would usher in a golden age of reproductive rights in which people across the country could access vital services without having to navigate an obstacle course of arbitrary government restrictions. It turns out that the golden age was short-lived. As you all know, this summer, in Dobbs v. Jackson Women's Health Organization, the Supreme Court overturned Roe v. Wade, abrogating the right to abortion 5 decades after it became part of the fabric of American life. This time, abortion opponents didn't have to resort to junk science to make their case. The Supreme Court didn't consider the evidentiary record at all. It relied instead on the historical record, explaining that because women's rights weren't widely respected at the time of the Civil War, they are not entitled to respect today. Never mind that the 14th Amendment was intended by its framers to mark a radical break with the state-sanctioned discrimination that characterized so much of our nation's early history. In the court's view, because states trampled on the rights of women during the early days of the Republic, women's rights aren't deeply rooted in our nation's history and tradition. And because women's rights aren't deeply rooted in our nation's history and tradition, states can trample on the rights of pregnant people today. It's hard to argue with logic like that. So what has Dobbs' impact been so far? A dozen states are currently enforcing bans on abortion at all stages of pregnancy. Several others are enforcing bans that begin early in pregnancy, months before viability is possible. As a result, many people are having to travel long distances to obtain abortion care, and many others are self-managing their abortions at home, often with pills purchased online without the assistance of a healthcare provider. It's too early to know how many people are being forced to carry unwanted pregnancies to term and give birth, but undoubtedly that is the outcome for people who are not able to travel and who are not willing or able to take on the risks of civil disobedience. In addition, hundreds of bills have been introduced in state legislatures to further restrict abortion and to punish people who provide assistance to prospective abortion patients seeking to travel to states where abortion is still legal. It remains to be seen how many of these bills will become law. At the same time, there have been some promising developments for people who support abortion rights. Several state courts have delayed or permanently enjoined enforcement of abortion bans, including courts in Arizona, Indiana, Michigan, Ohio, South Carolina, and Wyoming. Further, since Dobbs, ballot initiatives seeking to undermine abortion rights have failed in several states across the country, including conservative-leaning states like Kansas, Kentucky, and Montana. So what comes next? My organization, the Lawyering Project, recently launched a strategic plan outlining our vision for protecting abortion access in the wake of Dobbs. Recognizing that we have a responsibility to support people seeking to obtain, provide, and facilitate abortion care in this new legal landscape, as well as an opportunity to reshape reproductive rights jurisprudence, situating it on a stronger and more progressive foundation. Our plan identifies several key initiatives. In the litigation arena, we'll file cases to strengthen protections for speech and interstate travel to ensure that people can get accurate information about abortion and travel freely across state lines to provide and obtain abortion care. We'll file cases to increase the availability and affordability of abortion in states where it remains legal by eliminating barriers to abortion access, like TRAP laws and parental involvement laws. We'll file cases to hold individuals and organizations accountable for efforts to harass and intimidate abortion patients, providers, and supporters, or to spread misinformation. And we'll file cases to lay the foundation for a new body of case law that connects reproductive rights with gender equality, racial and economic justice, and religious liberty. This will necessarily entail a mix of federal and state court litigation. In addition, we plan to provide legal support to individuals and organizations that are developing, studying, or implementing innovative models of abortion service delivery, and to develop a program focused on providing general counsel support to abortion funds and practical support organizations which are coming under increased scrutiny from hostile state regulators. Finally, we just launched a major new initiative called the Abortion Defense Network. Led by the Lawyering Project, the Abortion Defense Network is a collaboration among public interest legal organizations, private law firms, and allied government agencies designed to ensure that all people facing liability for seeking, providing, or supporting abortion care have access to values-aligned attorneys who can provide high-quality legal advice and representation. It is our hope that the attorneys participating in the network will help people understand their legal rights, help them implement risk mitigation strategies, and if necessary, successfully defend them against criminal prosecution, civil lawsuits, and administrative proceedings. If anyone here would benefit from that kind of legal assistance, or if you know someone else who would, you can request help at the Abortion Defense Network website, which is simply abortiondefensenetwork.org. In closing, although I have definitely had moments of despair over the past year, I still believe that reproductive justice is possible and that working towards it is a moral imperative. I hope that all of you will join me and my colleagues in the struggle. Thank you. I'd be happy to open the floor for questions. I'm also happy to answer questions informally during the reception, but if anyone would like, I know we're all waiting to get our glass of wine, but if anyone would like to ask a question now, feel free. Yes.
I guess like in the face of the current Supreme Court that we're dealing with and what you were talking about in regards to the Dobbs decision, what do you think like the future of strategic litigation is going to be going forward in terms of ensuring the rights that we should be afforded under Roe?
I think going forward, we're going to need to have a mix of state court litigation and federal litigation. I think in the state courts, there remains the opportunity in the short term to argue in favor of abortion rights, to argue that state constitutions afford greater protection than the federal constitution, and to explore other sources of constitutional protection for abortion rights besides the liberty, the liberty that's guaranteed by the federal due process clause, like equal protection or protections for religious liberty. At the same time, I think there will be both an opportunity and a need to explore other federal rights in federal court to defend against restrictive new legislation that's seeking to interfere with people's ability to travel to access abortion care. And so I think litigation about the First Amendment protections of free speech and free association, as well as religious liberty, will come into play to some extent, as well as the right to interstate travel and the protections afforded by the Dormant Commerce Clause to cross state lines in order to engage in commercial activity. I think litigation is going to be needed in federal courts to vindicate some of those federal rights going forward, or to see to what extent the Supreme Court is willing to vindicate those rights. Yes?
You brought this up in your answer, but I'd love to hear your thoughts on the viability of some of the freedom of religion challenges. I've been seeing a lot of those in the news. If you think maybe they'd be stronger in some states with stronger state constitutional protections, or I'd love to hear if you think how successful those might be.
Yeah, I mean, I think it's an open question, and that it may be a long journey towards recognizing religious liberty as a source of abortion rights, but that journey has to start somewhere. And so I think it's important to start laying the groundwork now for how we want to see the jurisprudence develop in the future. And I don't really see any downside to exploring the possibility of religious liberty as a basis for abortion rights, both in federal and state courts. And I think sort of the more that advocates start to bring those kinds of claims, the more that people will start to think about abortion rights in that way. And there may be some challenges that are more primed for short-term success than others, and it just, I think, remains to be seen how those cases are going to be received by the courts. But I think it's very exciting that we're starting to see more and more of that mode of argument. Yes?
Pivoting away a little bit from the topic, you are obviously extremely accomplished and have had what I would regard as a fulfilling career despite the setbacks. What advice would you give young women who are entering or about to enter law school on building a meaningful career?
I mean, my advice is first and foremost, follow your passion. I got that advice from a mentor pretty early in my career. I started my career working at a large law firm doing commercial litigation, and that's good work. It's important work. There's nothing wrong with that, but it wasn't my personal passion. And so when I had the opportunity to apply for a fellowship at the Center for Reproductive Rights, I took it, and it sort of set me on a path that I've found to be very rewarding, if not altogether successful. But so that's my first piece of advice. My second piece of advice is don't be discouraged if your path isn't linear. When I came to law school, my dream was to work for the Department of Justice, actually. I wanted to be a government lawyer. But while I was here, the presidential election didn't go quite how I had envisioned it. And the leadership at the Justice Department, when I was ready to enter practice, wasn't quite aligned with my vision of civil rights and what I wanted to focus my career on. So I went to work at a law firm, and then actually from there I took a clerkship, and that's at what I thought was going to be the conclusion of my clerkship. I started applying for fellowships, and the first time around I didn't get any. Like, I struck out. I was like 0 for 8 or something, and I was going to go back to the law firm, and I remember one day just like crying in my judge's chamber saying, "I'm going to go back to that firm. Nobody would hire me." And she invited me back for a second year in the clerkship and was like, "This time you're going to work harder, you're going to build your networks, you're going to talk to people, you're going to, you're going to lobby for the position that you want." And I did, and I was very lucky that the second time around I was able to get a fellowship at the center. But don't give up. It doesn't always work out the first time. It doesn't always work out after the first 20 years, but you just keep at it. You build a strong team around you, and eventually, you'll make progress. Yes, in the back.
What do you see as the best way to ensuring abortion access, like equitably, especially for marginalized communities who don't have access to interstate travel resources and things like that?
Yeah, I mean that's really a critical question right now, and I'm not sure that there's a great answer. There are a lot of really wonderful organizations out there that are dedicated to providing financial assistance and practical assistance to people seeking abortion care, and they can help defray the costs and the burdens of interstate travel for some folks. But for folks who just aren't able to travel regardless of, the availability of financial assistance, maybe because they have dependents, that they can't travel with, maybe because of their immigration status and it's not safe for them to travel, or, maybe because they have a job where they can't get paid time off. People in that situation are just in a really terrible position right now, and civil disobedience is one option that's available, and it certainly carries risks. It carries legal risks, both for the person seeking abortion care and also for anyone that helps that person. But I think that this really needs to be the focus of our collective energy and resources, is figuring out how the most vulnerable people and people in the most vulnerable communities are going to get access to the care that they need. So thank you very much again, and thank you to the Law Women.
We want to thank you all again for joining us this evening. Many thanks to the Office of Development and Alumni Relations and Kelly Spencer for organizing this wonderful event. Thank you also to Dean McKenzie for being here tonight. And lastly, thank you to Stephanie Toti for taking time out of your very busy schedule to be here. And for sharing your remarkable story, perspective, and experiences with us.
We are so grateful that Law Women can create a space for all of us to come together and hear from such inspiring people about the crucial work that they are doing. We know that recent developments in the legal and political landscape, especially in regards to women's rights and gender justice, can feel demoralizing at times. We are so glad to be able to honor those who are directly working on these issues and to provide the younger generation with a direct example of the tangible good that can be done with a law degree. Law Women is committed to equipping the next generation of women with the tools, connections, and resources to step into these roles when the time comes. We can't wait to see what you all will do in them. Thank you all, and enjoy the rest of your night.